You know those stories, right? The classic neighborhood drama? Someone gets a fine for planting the wrong colored flowers or leaving a trash can out for like an hour too long. Well, what happens when one of those little disputes over something as simple as a tree and a mailbox spirals into a full-on legal war? We're about to walk through a real case where one homeowner decided to fight back against their HOA, and the result? Well, it's a wild ride through rules, reason, and some seriously bizarre mistakes.
So here's how we're going to break this all down. First, we'll meet the key players. Then we'll dig into the two central fights, the trees and the mailbox. After that, we'll get to the judge's big decision, which is a real curveball. And we'll wrap it all up with a final twist that I promise you won't see coming.
All right, so let's set the scene. We're in the Camelback Country Club Estates in sunny Arizona. Our main characters are Jon Paul Holyoak, he's our homeowner, and of course, his homeowners association. And their entire conflict, this whole legal battle, really just boils down to two things on his front lawn.
Yep, you heard me. An olive tree and a mailbox. What started out as, just a friendly little notice in late 2017 got serious fast. The HOA started slapping him with fines, and by February of 2018, Holyoak was done. He filed a formal petition and decided to take the whole thing to an administrative law judge.
First up, the trees. And this is where a pretty simple issue about yard work turns into this whole debate over what words actually mean.
So the HOA side of this was, pretty straightforward. In their notices, they were very clear. We see a dead olive tree, we see dead branches on other trees, get them out of there. From their perspective, it was just a clear-cut case of property maintenance.
And they weren't just making this up, right? They were pointing to a specific rule, Section 28 of the Community's Rule Book, the CC&Rs. That rule says everything has to be neatly trimmed and properly cultivated. And, well, their argument was pretty simple. A dead tree is neither of those things.
And this is where you see the two totally different realities. The HOA is looking from the street saying, dude, it's got no leaves, it looks dead, period. But the homeowner, Mr. Holyoak, he's like, whoa, hold on a second. It's not dead, it's in distress. My landscaper and I are trying to save it. So he's arguing that he is properly cultivating it, which is exactly what the rule asks for.
Okay, now for the second issue, and trust me, this one gets even messier, the mailbox. And this wasn't some new thing he just put up. This thing had been sitting on the property for years.
The HOA's position here seemed really simple on the surface. They saw two mailboxes, one built into this big monument thing, and another one standing by the curb. They checked their files, saw no approval for the second one, and said, it's an unapproved modification, it's gotta go.
So the HOA is saying it's an eyesore, it's not approved, but Holyoak comes back with this really powerful defense. First, he says it was there when he bought the house back in 2012, and nobody said anything then. But here's the kicker. The U.S. Postal Service made him have it. The mail carrier literally would not deliver his mail to the other mailbox because it was too far from the curb. So his hands were tied by the feds.
And this is where the HOA's case really starts to look a little shaky. Check this out. Over a few months, they cited 3 different rules for the exact same mailbox. First, they said it was disrepair. Then they said it was a violation because you can only have one dwelling. And finally, they landed on structure needs committee approval. That kind of inconsistency, it was going to be a problem for them.
Okay, so after all the letters, the fines, the arguments, the case finally lands in front of Administrative Law Judge Tammy Eigen here. She hears both sides of the story and comes back with a split decision that probably nobody saw coming. So first things first, the trees. On that count, the HOA wins.
And the judge's reasoning was basically a common sense test. She said that while Holyoak claimed the tree was just in distress, he never actually provided any proof, like a note from an arborist. So she concluded that any reasonable person walking by would think the tree was dead, and a dead tree, by definition, isn't being properly cultivated.
But then we get to the mailbox. And here, the tables just completely turn. The homeowner, Mr. Holyoak, wins this one. So why did he win? Well, the judge basically called the HOA out on that shifting rationale we just talked about. The specific rule they fined him under, Section 12, about having one single-family dwelling, was just plain wrong. The judge pointed out the obvious. A mailbox is not a dwelling. And because they used the wrong rule to fine him, the entire action was invalid. And, this wasn't just a moral victory. It came with a check. The judge ordered the HOA to cut him a check for $500 to cover his legal filing fee. So in the case of the mailbox, he was officially the winner. But just when you think it's all wrapped up, the justice has been served, the story takes this one last, kinda hilarious twist. It's a perfect reminder that even the official legal system is run by, actual humans who make mistakes.
So, to get this last part, you gotta know about this legal term, nunc pro tunc. It's Latin, but all it really means is, oops, we made a typo, and this new order fixes it like the mistake never even happened. It's basically a legal do-over for clerical errors.
So, on May 30th, just a few days after the big decision, the court has to issue one of these oops orders. Why? Because in the final verdict document, they had mixed up the case numbers. It was a simple typo, but a pretty big deal to get right.
And this is where it gets truly amazing. The very next day, they had to issue another one of these correction orders. You won't believe why. They had made a typo in the first correction order itself. They literally had to issue a correction for their correction. You can't make this stuff up.
So this whole wild ride, from a tree that may or may not have been dead to a federally mandated mailbox, all the way to a typo on a typo, it really makes you think, doesn't it? HOAs exist to keep a neighborhood looking good, but this case is a perfect example of how that can crash right into a homeowner's rights and just plain old common sense. It leaves you wondering, where exactly should we draw that line?